Hello, everyone, and welcome to today's live broadcast, Interplay between Federal Law and State Law regarding Marijuana Laws, presented by Jeffrey Matura. He is a founding shareholders of Barrett and Matura. I am Marjorie Torres of LabRoots, and I will be your moderator for today's event. We are delighted to bring you this educational web seminar presented by LabRoots. LabRoots is the leading scientific social networking website and producer of educational virtual events and webinars. Before we go, I would like to remind everyone that this event is interactive. We encourage you to participate by submitting as many questions as you want at any time you want during the presentation. Just click on the Ask a Question box located on the far left of your screen and type your questions into the drop-down box that appears on the screen. We'll answer as many of your questions as we have time for at the end of the presentation. If you have trouble seeing or hearing the presentation, please click on the Help Desk button located in the promotional board at the bottom or center of your screen, or use the Ask a Question box to let us know that you're having a problem. This presentation is educational and thus offers continuing education credits. Please click on the Continuing Education Credits tab located in the top right corner of the presentation window and follow the process to obtain your credits. Please join me in welcoming Jeffrey Matura. I will now turn the presentation over to him.
Good afternoon, everyone. I appreciate the opportunity to speak to you today about a topic that I certainly find fascinating, and I hope that some or hopefully all of you will find fascinating as well. I am an attorney located in Arizona, and so my topic today is to talk about laws that govern marijuana. And it wasn't that long ago that just having this discussion alone would be illegal to even talk about different ways to use and produce and test marijuana in any purpose. And so here we are in 2018, and we're able to have a conversation about laws that have developed and are developing right in front of our faces. Every day the law is developing in this area regarding regulation of marijuana across the country. And frankly, we're seeing it across the world. But what I'm going to talk to you about today and hopefully educate somewhat today is this conflict that exists in the United States. And it's something that certainly myself and other lawyers who work in this area have to deal with on a daily basis. And the conflict is between the federal law issued and enforced by the federal government and state laws. We have many states, and we'll talk about the states in a little bit, but many states developing laws. Every legislative session across the country, you see different states coming up with different laws. And so what we're going to talk about today is how the federal law and the state laws play together. They don't play very well together, but we're going to talk about how they play together, where the conflicts are, where there's no conflicts, and perhaps where we think this whole area of the law is going. And it touches every aspect of this industry, whether you're a producer of marijuana, a seller of marijuana, a user of marijuana, a real estate agent who is helping someone open up a business, a scientist who is testing the product, a doctor who might have a patient that wants to use the product, and everything in between. It truly does touch every industry that we have in society right now. So understanding the laws and how it all works, I think, is an important topic. So that's why the title of my presentation is The Interplay Between the Federal Law and the State Laws Regarding Marijuana. So we're going to start, and of course I messed up my very first slide, but we're going to start with giving an overview of the federal perspective on marijuana and the state perspective on marijuana. Make sure we all start from the same point. So the federal perspective is that marijuana is a controlled substance under federal law. What that means, it's illegal to possess it, to sell it, to use it, to produce it, to touch it, period. Marijuana has always been and still is today considered a controlled substance or illegal under federal law. Again, this law prohibits the manufacturing, sale, and use of marijuana in all 50 states at all times. That's the federal perspective. The state perspective, of course, is a little bit different. 29 states, including DC, have passed laws to permit the medical use of marijuana. We're going to talk about what medical use means in a little bit. But we have 29 states, so we have more than a majority. And this time next year, it'll be more, and 2, 3, 4, 5 years from now, it'll be even more states. It's important, I think, to note and to understand that you have a majority, more than a majority of the states who have passed some type of laws permitting the medical use of marijuana. Once we tipped the scale, and we tipped the scale a few years ago to get more than 25, there really was a watershed moment from the law's perspective, because now the court system and the judges and those other individuals that operate under the law can see pretty clearly that we have a national mandate, if you will, about which way the population is going. So we have 29 states, including DC, with medical use laws. We have 9 states, including DC, or excuse me, in addition to DC, that have passed laws that permit the recreational use of marijuana. So recreational use is a newer trend in the law. It's trailing medical for perhaps obvious reasons. It's more palatable to state legislators and to governors to sign laws into their respective states that first address the medical use. You have children who are having seizures every day that suddenly are not. You have debilitating conditions that are a little bit better to live with. You have someone with chronic pain who can't get up in the morning and walk, but if they have a doctor's note, an appropriate medical note, and take medical marijuana, suddenly their lives are improved. So that's why the medical laws usually are leading the charge, and the recreational laws fall a little bit behind. What does recreational use mean? Sometimes we'll hear it referred to as adult use. So recreational use does not mean anyone. You have to be over 21, and we'll talk more about this later. You have to be over 21, and you still have certain restrictions on the use of that marijuana. But recreational does not mean everyone. At a very minimum, it means someone over the age of 21. So that's the overview, the 2 perspectives that we're going to talk about today. Again, the overarching issue of what I want to talk about is how does a business or an individual involved in some manner of the production, sale, or use of marijuana, whether medical or recreational, operate under the conflicting federal perspective as compared to the state perspective. So the first place we're going to start as we dive into this topic is we're going to start with the federal law. We're going to start with the federal perspective, if you will, and why the government has the perspective that it has. And that brings us to a federal law known as the Controlled Substances Act. It was a law that was passed by Congress in 1970, signed into law by President Nixon. It's a very long statute. It's incredibly boring to read, but what it does is it classifies regulated substances into 5 different schedules. Literally, if you looked on the page, you would see sheets with drugs listed on them. It's enforced by the Drug Enforcement Agency as well as the Food and Drug Administration. And they have lists of schedules, they call them. And there's 5 schedules, Schedule 1 through Schedule 5. Schedule 1 being the most severe in the eyes of the government drugs, the most severe drugs in the eyes of the government. And then it goes down in severity until you get to Schedule 5. If you looked it up online, you could literally read the different drugs that are listed on these different schedules. Marijuana is currently, and has been since 1970, and is currently today, listed on Schedule 1 of the Controlled Substances Act, meaning Congress believes it's the most severe form of drug. Other drugs, for examples and comparisons, listed on the Schedule 1 page are heroin, LSD, ecstasy. These are all very severe and serious drugs. And in the eyes of Congress, they compare marijuana to be the same. What does it take to be a Schedule 1 drug? Believe it or not, Congress has set some parameters to govern themselves to determine what should be a Schedule 1 drug versus a Schedule 2 drug versus a Schedule 3 drug, etc. So Congress has set forth some qualifications to justify the inclusion of any drug on the Schedule 1 list. And here's what Congress says. A Schedule 1 drug has to have a high potential for abuse. It has to have no currently acceptable medical treatment for its use. And it has to have a lack of accepted safety for its use, even under medical supervision. So think about that for a second in the context of, well, let's start with the context of heroin. Perhaps we could all agree that there's very high potential for abuse with heroin, and probably people much smarter than myself could maybe think of some acceptable medical treatment for heroin, but I think we could all generally agree that heroin doesn't have an acceptable medical use. And I think we could all probably agree that individuals don't safely use heroin, or certainly there's a risk for the unsafe use of heroin. So heroin, ecstasy, LSD, we could all have a conversation where we could find some common ground to justify that it should be a Schedule I drug. But now take these three parameters and apply them to marijuana. High potential for abuse. Well, we see across the country that individuals of all different characteristics are using marijuana and not abusing it. There are always exceptions to every rule, but by and large, we could agree that individuals can use marijuana without abuse, certainly not a high potential for abuse. Secondly, no currently acceptable medical treatment for use. Well, we know from time now and from the last several years that there can be acceptable medical use of marijuana, and it can work wonders in children and adults with different conditions. We know that because we see it, and it's happening all across the country today. And then lack of accepted safety for use, even under medical supervision, well, that's directly contrary to what is happening across the country in states that permit it for medical use today. So you take these three parameters, or these three qualifications, if you will, you try to apply them to marijuana, and it doesn't quite fit when you look at what's actually happening across the country. Now, Congress doesn't care. They don't have to care, but they certainly don't care that these three characteristics don't evenly and nicely apply to marijuana. Marijuana has been a Schedule I drug since 1970, and it still is today. So what does that really mean? What difference does it make if marijuana is a Schedule I drug versus some other schedule under the law? Well, it actually means a lot. Licensed doctors are not allowed to prescribe marijuana. It's contrary to their licensing, and they can lose their license as a medical doctor if they were to prescribe marijuana, even in those states where medical marijuana is legal. As a Schedule I drug, clinical studies are not going to happen. They're prohibited by law. So you don't have an influx of money and resources and researchers and scientists who are willing and able to do true clinical trials and studies on the effects of different types of marijuana. And there are as many different strands and types of marijuana these days as your mind can possibly imagine, but absolutely zero clinical studies on the impacts and long-term effects and benefits and strength, et cetera, of those drugs. As well as no clinical studies, there's truly no significant research on the safe use of marijuana, because again, it would be the same as doing research on heroin, and that's not permitted under the law. So by being a Schedule I drug, the government has hindered very much the development of the safe use and the research and the study and the science behind the use of marijuana. As I've said a few times now, marijuana remains a Scheduled I drug today. Every year since 1981, there's been a bill introduced by someone in Congress to remove marijuana from Schedule I to at least Schedule II, move it down a notch. If you move it down just one notch, it opens up the ability for research, clinical studies, et cetera. Every year since 1981, there's been a bill introduced, and every single year that bill has not even made it out of the legislative committee, which for those who aren't familiar with how Congress works, it's essentially it hasn't made it out of the starting gate yet. Not even to the point where it can be debated, amended, and certainly it's never come up for a vote in Congress. It's not even out of the starting gate yet. There's another way to try and get it changed, and that's for someone to petition directly to the DEA, to the Drug Enforcement Agency, to have it remove the drug from Schedule I to some other schedule. Every single petition that the DEA has received since 1970 has been rejected outright. What's interesting is that tobacco and alcohol are specifically exempt from Congress from the Controlled Substances Act. Why is that the case? Well, tobacco and alcohol have more history behind them in terms of use in the United States. Tobacco and alcohol have a lot more money behind them when it comes to lobbying efforts and financial pressure, if you will, that can be placed upon members of Congress. And they're just frankly viewed differently in today's society. Marijuana has not certainly caught up at all with the views of tobacco and alcohol. We are very far away from the day when you can go to your local corner store and buy marijuana, but you can certainly go there today and buy tobacco and alcohol. Some would argue that tobacco has a high use for misuse, as does alcohol, that there can be harm brought to the person unless under the supervision of a doctor. You could apply the same characteristics to tobacco and alcohol that you apply to marijuana, but they're just treated differently because there's more money and more history behind them. And there's no similar exemption for marijuana, nor is there the suggestion by Congress that they're interested in such an exemption. So when it comes to marijuana and the federal perspective, it's very easy to understand what that perspective is. That perspective is marijuana in every form is illegal 100% of the time in every corner of every state of the United States. There's no exception, period. Perspective on marijuana. I want to move to the state perspective on marijuana. And despite everything I just spoke about, despite the complete and absolute illegality of marijuana under federal law, we have states that have decided to go against the grain. And we know that states have passed marijuana laws to permit the production, the sale, and even the use of marijuana. But it's not an absolute situation. They've passed these laws subject to certain regulated circumstances. There are two broad categories of state laws. There's, of course, as we've been talking about here today, medical marijuana laws, and then there are states that have created recreational or adult use marijuana laws. Now, we're going to look at a map of the United States, which is going to help explain where these states are located and what kind of laws they have. This is a map which was put together by the Business Insider. It's up to date through the last, through the legislative sessions in 2018 in the various states. You'll see, as the map tells us, that the green states have legalized recreational and medical marijuana, and the blue or gray states have legalized medical marijuana only, no recreational use. Again, as we spoke about earlier, we have more medical marijuana states where it's permitted than we do where recreational use is permitted. What's interesting to see as we look at this map is legalized recreational marijuana was primarily on the West Coast. Colorado, California led the charge, then Washington, Oregon jumped on board. Nevada recently started, but primarily on the West Coast is where it's been, except for most recently when we now know that Vermont, Massachusetts, and Maine have passed laws to legalize the recreational use of marijuana, which means it no longer can be viewed by Congress as just a quote unquote liberal West Coast type mentality. For medical marijuana, the map shows that it's spread fairly evenly across the United States. If we look at this map a year from now, there are going to be more blue states on this map. Utah is taking the steps right now to have a ballot initiative to pass medical marijuana in other states as well. So the theory is, and the prediction is, that eventually most, perhaps not all, but pretty close to all states will have some form of law that permits the use of marijuana, whether it's for medical or recreational. Again, it'll be interesting to see what this map looks like a year or 2 years from now. I strongly suspect it'll have more color on it than it does even right now. I want to do a quick comparison because although we have 29 states that have medical marijuana laws plus DC, not every state is different. And frankly, there are 29 different versions of laws because every state is different. I just want to do a quick comparison of two states to underscore, even within the state level, the laws are not the same. So depending upon where you are and what jurisdiction you're sitting in and what your use of that marijuana might be, whether it's studying it, testing it, using it, selling it, etc., the laws are different. So I just chose two states, Arizona and Florida, that have medical marijuana laws. Arizona, you can obtain a medical marijuana card if you have a qualifying medical condition. It's a card like a driver's license issued by the state of Arizona. You have to have a qualifying medical condition, and that phrase means something different for every state. In Arizona, if you have cancer, that's a qualifying medical condition where you can get a card. Florida is the same thing on this issue. You need to have a card that you carry with you in your wallet at all, or on your person at all times when you have marijuana on your possession. And you have to have a qualifying condition as well. So in this respect, medical marijuana laws are the same. But then you can start to see the differences if you dig a little bit deeper. In Arizona, you can purchase with your medical marijuana card up to 2.5 ounces of marijuana every 14 days. And there's a system that the state uses to track how much you purchase, because when you purchase it, your card and your card number gets put into the state system. Therefore, if you go to a dispensary and you buy 2.5 ounces on Monday, and then you go to another dispensary on Tuesday to buy another 2.5 ounces, a big red flag will come up on their screen. And if they're following the law, they will not sell you any more marijuana until your 14 days has run. Florida, just again, by way of comparison, is quite different. In Florida, if you have a qualifying card, you can purchase the amount reasonably presumed to be necessary for your medical condition as determined by a physician. That could be a great variance depending upon the person. Someone with a back pain issue might be treated differently than someone with terminal cancer, for example. So how much are you allowed to purchase in Florida and over what time period? It varies from person to person. Now you'll see on the screen here that it says under Florida law, as determined by a physician. And I've already told you that physicians can't prescribe medical marijuana. So how does that work? Well, again, just by way of an example, in Florida, you actually have doctors that are identified as what they call marijuana doctors, for lack of a better phrase. And they're not doctors in the traditional sense, seeing patients for various sicknesses and illnesses. They've been authorized by the state of Florida to help facilitate their state-mandated medical marijuana program. So these are just two examples. Again, every state is different. You could have 29 different examples on the screen. The point is that when it comes to medical marijuana, not only is it contrary to federal law, but every state law is also different. The same is true when it comes to those states that permit the recreational use of marijuana. I've chosen two states at random, Oregon and Washington, just for comparison's sakes. Oregon, you have to be 21 years or older to legally purchase and use recreational marijuana. Same thing for Washington. And that's fairly standard across all states, at least at that basic level. You have to be 21 years or older. In Oregon, you can legally purchase and possess 1 ounce of marijuana flower. The same happens to be true in Washington. But then the differences start to appear as you dig a little bit deeper into what you might buy with a recreational card. In Oregon, you can buy 5 milligrams of edibles. In Washington, 10 milligrams of edibles. In Oregon, you can buy 5 grams of concentrates. In Washington, you can buy 7 grams of concentrates. Why 7? No answer other than that's the number the legislature decided on. Probably a compromise between 5 and 10, but I don't know that to be for fact, but they came up with 7. Again, the point here is within the recreational laws, there are differences, and depending upon where you're located, what you're doing with the marijuana, it doesn't have to be using it. It could be testing it. It could be producing it. It could be selling it. The amount that you're allowed to have on your possession at any point in time varies. Now, there's no question that the production, the sale, and the use of medical and recreational marijuana is booming across the United States. And I have this slide to underscore that this is a big money business. There is no debate about that. For example, in 2017 alone, medical marijuana sales topped $3.2 billion across the United States in the 29 states that permit medical marijuana. That's a big number in 2017 alone. In 2017, recreational marijuana sales was $4.5 billion, and that's only in 9 states plus Washington, D.C. If you look at the projections going from 2017 through 2025, assuming no more states pass laws to legalize the medical or recreational use of marijuana, projections put it at $131.8 billion from today through the end of 2025. The numbers are exponential and the growth is exponential. So while you continue to have federal law saying you can't touch, use, test, or frankly even look at marijuana without committing a crime, at the same time you have that, you have projections of $131.8 billion of sales of marijuana between now and 2025. So the conflict is great. There's no question about that. I now want to turn the conversation a little bit to some of the laws that apply across the board. And I thought the best place to start was with the highest court in the land, the United States Supreme Court, because the United States Supreme Court has commented at least one time on this issue and the conflict between federal law and all of these state laws that are popping up every year. There was a case back in 2005 that went before the United States Supreme Court. It was called Gonzalez versus Reich. What the case involved in its most simplistic level, you had 2 California residents who used doctor-recommended marijuana pursuant to California's medical marijuana laws, and their marijuana plants that they were growing under California law, so it was completely legal under California. The federal government, through the DEA, came in and seized and destroyed their plants. And they said, hey, you can't do that. We're complying with California state law. What more can we do? You can't come in here, government, and tell us we can't comply with our state law. The case worked its way through the court system, and many years later, it found itself at the front steps of the United States Supreme Court. Well, the Supreme Court concluded that 2 residents in California, you're wrong. The Supreme Court concluded that the federal government has the constitutional authority to prohibit marijuana for all purposes, and that federal law enforcement officials such as the DEA, the FBI, et cetera, can prosecute medical marijuana patients even if they're complying with their state-passed medical marijuana laws. So what does that mean? It means that the Supreme Court reaffirmed the government's authority as being the highest law of the land when it comes to marijuana, and that it does not have to agree with or take a hands-off approach when it comes to state marijuana laws. Now, the United States Supreme Court did not go as far to say that state marijuana laws are unconstitutional. It didn't go that far, but it very much reaffirmed the government's right to come in and to enforce its law, even in states that have their own marijuana laws. Now, that was 2005, and that's a pretty strong affirmation of the government's position as of 2005. Since that time, we've seen some softening of the government's position when it comes to medical and recreational marijuana laws. And I want to talk about some of those softening positions now. During President Obama's administration, we saw somewhat of a change in the government's positioning and perspective. More states passed medical marijuana laws as well as recreational laws. Public opinion continued to tilt in favor of additional laws permitting the medical and recreational use of marijuana. So you had this groundswell of support and the anticipation of change in the government's position. And then you had President Obama come out himself on January 18th of 2014. During one of his many press conferences, he made the following statement. He said that he doesn't think that marijuana is more dangerous than alcohol. Now that might seem like a off-the-cuff comment. It might seem flippant. It might not seem like such a big deal in the grand scheme of things. But that comment coming from the president at the time really was a monumental moment for the marijuana industry. Because if you think back to the Controlled Substances Act that we talked about earlier, alcohol is exempt, tobacco is exempt. If you think about the qualifiers to have marijuana as a Schedule I drug that we talked about, one of them is the danger from the misuse of that drug. And here you have the president saying that he doesn't think, in his opinion, that marijuana is more dangerous than alcohol. It certainly opened the door for a change in the government's perspective. We then had something called the Cole Memo. And the Cole Memo is literally a written memorandum drafted by someone with the last name of Cole, James Cole, who worked for the Department of Justice. He was a United States Deputy Attorney General under President Obama. He worked for the Department of Justice under President Obama's administration. And he wrote this memorandum, which came to be known as the Cole Memo. And what he did in this memo, and this is critically important, what he did in this memo is that he set forth new guidelines for federal prosecutors across the country to follow when dealing with the medical or recreational use of marijuana. You could look it up online and read it. It's a memo that says, we want you to change how you prioritize using federal resources to enforce federal law in states that have medical or recreational marijuana laws. So it was a big shift in perspective. It shifted the government priorities away from the strict enforcement of federal marijuana prohibition and shifted it more towards a hands-off approach, at least with respect to those states that have medical and recreational marijuana laws. So what was the impact, the practical impact of this memo? Well, the number of federal marijuana prosecutions declined in those states that have medical or recreational marijuana laws. Those states continued to pass additional laws, as well as new states came on board without the fear of exposing producers, sellers, users to federal prosecution. And then marijuana businesses within those states expanded their production and sale of marijuana and marijuana-related products because they believed they had some protection. It's not a law. The Cole Memo is not a law. It's not passed by Congress. It's not signed by the president. But it is direction and guidance to the federal prosecutors throughout the country to shift their priorities perhaps away from the strict enforcement of federal marijuana laws and towards more of a hands-on approach, so people felt a little bit more free to comply with the state laws without the fear of arrest and prosecution. All right, we had the Cole Memo. We now have something called the Rohrabacher-Farr Amendment. This is the next step in somewhat of a softening of the government's approach towards the enforcement of federal marijuana laws. This amendment, which was introduced by two representatives, one with the last name of Rohrabacher and one with the last name of Farr, was introduced in 2001. And what this amendment through Congress said was that the Department of Justice would be prohibited from spending money given to it by Congress through the budget, be prohibited from spending money to interfere with the implementation of state medical marijuana laws. Again, what this amendment said was, hey, Department of Justice, we're going to give you a bunch of money through the budget process in Congress to run your entire operations, and you can only imagine how big of a number that is to run the Department of Justice. However, this amendment said you can't use a penny of that money to interfere with the implementation of state medical marijuana laws. Introduced in 2001, finally became law in 2014 as part of Congress's omnibus spending bill, which is a fancy way of saying the budget for that year. President Obama was president during that year, and he signed the omnibus bill, and part of that bill was this amendment. It's the first time that Congress passed a law, and it was signed by the president into law, to give some amount of protection to medical marijuana users. This is the actual text of the 2014 amendment. It says that none of the funds made available in the act to the Department of Justice may be used with respect to the states of, and then it lists all of these states from Alabama through Wisconsin. It's not all 50 states, but it's a good number of states. So the text says none of the funds can be used with respect to these states to prevent them from implementing their own state laws that authorize the use, distribution, possession, or cultivation of medical marijuana. It's not a long amendment. It's not pages and pages of legalities. It's one paragraph, but it's a very important paragraph. Now, it's a great amendment for those involved in any respect with medical marijuana, but it has its own limitations. It only applies to medical marijuana. It does not apply at all to those laws dealing with recreational marijuana. So there is no limit on the Department of Justice using all of its money, if it wanted to prosecute anyone involved with recreational marijuana, whether it's producers, sellers, users, testers, anyone at all. The Department of Justice is not restricted. The other issue with this amendment is that it must be renewed every year. It's only effective as long as that budget bill is effective. And so every year, and sometimes multiple times a year, if a full budget's not passed and they have temporary budgets, every time the word budget is coming through Congress, this amendment must be attached to it. It's therefore often used as a political tool. Congress members will use this as leverage to achieve something else that they might want in the budget deal, because Congress members know that this amendment is critically important to this industry, and it must be included and approved in every single bill that goes through Congress when dealing with the budget. Now, that came into law in 2014, and it's been part of every budget bill since 2014. Obviously, we've had a change in presidents since 2014, a change in the administration, and what I want to talk about now is a change in perspective of the government since Donald Trump became president. We have a new Attorney General, Jeff Sessions, who took office and was confirmed when Trump became president. Well, on January 4th, 2018, he affirmatively rescinded the Cole Memorandum that we talked about earlier. And if you remember what the Cole Memorandum is, it was guidance given by the Department of Justice under President Obama for federal prosecutors across the country to shift their focus away from enforcement in states that had passed medical marijuana laws. Well, on January 4th of 2018, Attorney General Jeff Sessions rescinded that memo. And here's what he said. And I don't like to read to you, but what he said is that he believes it's the mission of the Department of Justice to enforce the laws of the United States. He says the previous issuance of guidance, he's talking about the Cole memo there, the previous issuance of guidance undermines the rule of law and the ability of local, state, tribal, and federal law enforcement partners to carry out this mission. By mission, he means, in his belief, the enforcement of federal laws. He said, therefore, today's memo, meaning the memo that he issued rescinding the Cole memo, directs all U.S. attorneys to use previously established prosecutorial principles to deal with criminal organizations, tackle the growing drug crisis, and thwart violent crime across the country. If you think about what this statement really means, you have the the Attorney General, the top guy at the Department of Justice, using words like criminal organizations, drug crisis, and violent crime in the context of marijuana and in the context of medical marijuana. So it's very much a shift in the rhetoric from one administration to another. So as of January 4, 2018, the Cole memo became ineffective, at least under the Trump administration. You have a new shift from Attorney General Jeff Sessions. So what's the real practical impact of what Jeff Sessions did? Well, now U.S. attorneys, and every state has one or more U.S. attorneys. They are the top federal lawyer or prosecutor, if you will, for governmental laws within each state. So Jeff Sessions said, hey, U.S. attorneys, you can use your discretion now, however you see fit, to determine whether to charge or prosecute producers, sellers, users, or others who have on their possession medical and recreational marijuana. It gave great discretion to each U.S. attorney to make their independent decision, whereas the Cole memo was a direction to shift their priorities. So it was a different perspective now from Jeff Sessions. He was very clear that in his opinion and from the government's position, state medical laws have no barrier to federal prosecution. His memo did set forth some criteria that he wanted the U.S. attorneys to consider when exercising their discretion. He wanted them to consider financial resources. How much money do they have with respect to their budget to go after and enforce federal marijuana laws? How serious is the crime that they're considering? Is it a 14-year-old child who has seizures every day? Or is it someone selling thousands of pounds of marijuana a month, even under a state law? And then what deterrence effect would actually apply by prosecuting that individual? So Jeff Sessions has asked his U.S. attorneys to consider these factors when making their decisions. But we've had a shift now from complete enforcement to the Cole memo under President Obama to the Sessions memo under President Trump. We are flipping back and forth when it comes to the exact perspective of federal law with respect to recreational and medical marijuana. So where are we now? It's kind of the million-dollar question, if you will. Where are we now? Today, we still have illegality under federal law. Marijuana remains illegal in all respects. We do not have any law from Congress signed by the president saying it's not illegal. We don't have any decision from the United States Supreme Court saying it's not illegal. It remains illegal under federal law today in all respects. But still, as we've talked about today, we still have more and more states coming online and passing their laws to create these situations where an individual can produce, sell, use medical or recreational marijuana. The amendment we talked about recently was again included in the spending bill signed by President Trump in March of 2018. So that bill, or excuse me, that amendment continues to be included in each spending bill. So despite Jeff Sessions' memo, despite what he has asked his U.S. attorneys to do, you still have this conflict because you still have this amendment saying the Department of Justice can't use any of its money to interfere with the implementation of state medical marijuana laws. So how does that amendment interplay with Jeff Sessions' memo? It's not frankly clear. You could have a situation, and I think this is the most likely answer to my own question, is you have the Attorney General, the highest ranking official at the Department of Justice, telling his U.S. attorneys to use their discretion, but they can't actually use that discretion to spend any money to interfere with medical marijuana laws. Again, it's very conflicting, but that's the situation that the government has created. And it's very likely that this shifting conflict will continue into the future. every presidential administration can decide how to deal with this issue. And frankly, if you go back and look just at President Trump and his stated beliefs on this issue, before he was a candidate, he was in support of the medical use of marijuana. As a candidate, his position, as stated on the record, was that it's a states' rights issue. States should be able to decide whatever they want to decide on this issue. The government should stay out of it, and it should be up to the states. Now, as president, you have his attorney general saying, no, it's a criminal syndicate. It's a cartel. It's, you know, these big words and rhetoric when it comes to marijuana. So it's very possible that this issue could change within a single administration as well. It only takes one signature from the president to change this entire dynamic. Public opinion remains strong for the medical and recreational use. If you look at some of the polls that have been conducted, 94% of voters favor medical marijuana laws in some respect today. That's a big number. That's a number that will get politicians' attention and members of Congress's attention. 60% of all voters favor laws regarding the recreational use of marijuana. That's a big number too. Not quite as big as 94, but it's more than 50%, which is always the threshold that you're looking at. So just going by polling and public opinion, there's going to be some pressure on members of Congress to deal with this issue. Despite these polling numbers, marijuana remains a Schedule I drug today, as we've talked about. At any point in time, Congress has the ability to remove marijuana from Schedule I or to give it an exemption as with tobacco and alcohol, but that hasn't happened, and there's no indication that it's going to happen anytime soon. So what do we do? What do we do with these conflicting laws? What can we do? And again, it doesn't matter what part of this process you might find yourself in, whether you're a lawyer like myself, whether you're someone that produces marijuana under a state regulated legal system, whether you're someone that purchases marijuana for yourself or for others, whether you're someone that uses marijuana, whether you're someone who is involved in some other industry that this hits, such as real estate, technology, science, research. It touches all parts of this industry. So what are you supposed to do? Because the minute you lay your hand on marijuana, or the minute we have a conversation about marijuana, we are violating federal law. This talk under federal law, I should say, this talk violates federal law. We're talking about how to use and how to weave your way through these different laws. So what do you do? What do you do? Well, unfortunately, there's not a lot of good advice, but it's the best we have right now. Number one, I always recommend that individuals understand the laws of the state in which they reside or work. As we saw earlier, the state laws are different, so understanding the state law is critical. Now, based upon Jeff Sessions' memo, I also recommend that an individual or a business understand the views of the U.S. attorney in that state where they reside or work. Jeff Sessions' memo gives discretion to these U.S. attorneys, so you could have 50 different opinions from U.S. attorneys on how they want to handle these issues. So understanding not only the state law, but the opinion and views of the U.S. attorney is important to know what you can and can't do with respect to however you're involved in this industry. I always recommend that individuals contact their local and federal level representatives and senators. Those are the people that are actually making the law that will impact this industry. Recognize that sustained prohibition has never worked in the long history of this country. We see public opinion where it is. We see a majority of states now having at least medical marijuana laws permitting the medical use of marijuana. You can project forward over the next 5 and 10 years thinking perhaps you'll have more than 25 states permitting the recreational use of marijuana. So prohibition is not an issue that is sustainable long-term in the United States. It just hasn't worked. Didn't work with tobacco, didn't work with alcohol. It does not appear to be working with marijuana right now as well. And then last, final issue here is, and this is what's fascinating to me on this topic, is that history on this topic is being made right now. Next generation, 2 generations, 3 generations down the road, people at that point in time will look back to where we are right now and say, that's where these laws were created. That's where this issue really came to fruition. If you talk to generations above you, to be able to say, hey, in some states, you can go down to a store and leave with marijuana in your pocket and it's legal. That concept is foreign to my grandparents, for example. So when you think back, or when you think ahead to the future generations, they're going to look back to right now and realize this is where this issue was discussed in an open forum, where laws were made, where the conflict existed, but out of conflict eventually comes some type of resolution, whether it's this year, next year, 5 years, 10 years down the road. At some point in time, I believe there will be resolution on this issue to resolve this conflict that we've talked about today. And then history will be made. Until we get there, of course, we have conflict, and we live in a world of conflict when it comes to this industry. But you have to go through the conflict to get the resolution. And it's very fascinating to me to be involved in this process and this time of our history to see how this all develops. So that's my talk for the day. I hope it's been moderately helpful and hopefully somewhat interesting as well. And at this point in time, I guess we would go to questions.
Thank you, Jeffrey Matura, for that informative presentation. We will now start the live Q&A portion of the webinar. If you have a question you'd like to ask, please do so now. Just click on the Ask the Question drop-down box located on the far left of your presentation window. Type your questions into the box that appears on your screen and click on the Send button. We'll answer as many of your questions as we have time for. Let's get started. Our first question is, how has the Trump administration changed the way the government views state marijuana laws?
Well, that's a good question. Every administration has handled marijuana laws differently when it comes to the states. And what we've seen with the Trump administration so far is, frankly, some back and forth, or flip-flopping, as they used to say. Right now, with respect to the Trump administration, is taking a very hardline stance against state marijuana laws. It would not be surprising to see the Trump administration try to get rid of the Rohrabacher or Farr amendment that we've talked about during this presentation, to put pressure on members of Congress to not include that amendment. Given the position right now of Attorney General Jeff Sessions, as long as he is Attorney General, it's anticipated that the federal crackdown, if you will, or the conflict between federal law and state marijuana laws will continue to become greater and greater. It could all change. Every administration is different. It takes one signature from the president to change things, but the anticipation right now is that federal enforcement will continue to increase under the Trump administration.
Thank you for that answer. Our next question is, what unintended consequences have occurred due to the government's decision to maintain marijuana as a Schedule I drug, particularly with respect to banking?
Yeah, this is one of the, banking is one of the most important unintended consequences of having marijuana be a Schedule I drug under the Controlled Substances Act. Because it's a Schedule I drug, banks are prohibited by law from taking any money derived from marijuana in any respect, whether that's money from the production, from the sale, from the testing, rent from a landlord for a tenant who runs a marijuana business. Any money derived in any respect from marijuana, banks are prohibited from taking. What that means is that those businesses operating legally under state laws in the marijuana industry cannot go to a bank and open a bank account and deposit money into it. And so it's created a cash-based system, largely, a cash-based system, which has its own problems inherent in it. You have sellers of marijuana under state laws who have to put their money in a safe as opposed to a secure bank account. So it's really, you can't transfer money from one account to another. You can't transfer it across state lines. The inability to use the banking system in this country has severely restricted how to handle the money that's generated. And we saw slides earlier talking about the billions of dollars in sales last year alone, and there's no place to put that money. So one of the most important unintended consequences is banking. If marijuana were moved to Schedule 2 or lower, then suddenly you'd have a mad dash to the local bank to open bank accounts as a place to securely deposit money derived from this industry.
Thank you for that answer. It looks like we have time for one more question. Our last question is, what is the future of marijuana laws on the federal and state level?
My belief, based upon what's happened over the last 10, 15, 20 years, I think what you're going to see in the next 15, 20, 30 years is that this conflict that we've talked about today is going to go away, either by a decision from the United States Supreme Court, or by a decision by a president, or a decision by a sitting Congress. All three of those bodies, the executive, the legislative, and the judicial branch of our government, they all have the ability to get rid of this conflict. And I think that's where this ultimately is headed. We will ultimately see a system where some form of marijuana use, either on a medical side or a recreational side, is legal across all 50 states. Restricted, but legal. It will then be taxed, it'll be regulated, it'll be tested, similar to alcohol, similar to tobacco. But I think that's the future of where this is headed, which is a uniform set of laws that govern all 50 states in this industry.
I would like to once again thank Jeffrey Matura for his presentation. I would also like to thank LabRoots for making today's educational webcast possible. Before we go, I want to let everyone know that today's webcast will be available for on-demand viewing through June of 2018. You will receive an email from LabRoots letting you know when this webcast will be available for replay. Please share that announcement with your colleagues who might have missed today's live event. That's all for now. Thank you for joining us, and we hope to see you again soon. Goodbye.